and playing in traffic. And you can dart across the street to get from one side to the other, heedless of the lights, and you can do it again and again and get away with it. You got to bat 1,000. You got to bat 1,000, and nobody bats 1,000. In a nutshell, now let me get into the statutes themselves. If anybody is involved in a financial transaction with money, and financial transaction is very, very broadly framed, a financial transaction, a buying, a selling, a lending, a pledging with money, or is involved in sending money overseas, or is involved in receiving money back from overseas. One, in order to promote criminal activity, meaning if this money has some shaykhs to some kind of criminal activity under basic American criminal law, or to violate the tax laws, or to hide the origins or the ownership or the location of money that is derived from any sort of criminal activity, or to avoid one of these reporting requirements. That's money laundering. That's money laundering. The scope is a broad scope. Basic criminal conduct, you say, how do you disengage this financial aspect, this money laundering from basic criminal conduct? Basic criminal conduct is out there. It's prevalent enough. I mean, I've read somewhere that they have these sniffing dogs that sniff for drugs at airports and the like, and basically they react to cash. They react to cash all over the place, because a lot of the money in circulation has somewhere, somehow, in some way, passed through some drug dealer's hands. But the answer to all of this is the element of intent. Is the element of intent that I've explained. Just to backtrack just a little because it's technical, it's not only engaging in a financial transaction or transmitting money abroad or receiving money. There has to be a particular knowledge or state of mind which transmutes, which changes this otherwise permissible financial transaction into money laundering. Again, if it's an attempt to violate the tax laws, if it promotes criminal activity, if it's hiding another crime, or if it's avoiding a reporting requirement. If it is done, if you engage in such a transaction with knowledge that one of those prerequisites has occurred, such a person will have engaged in money laundering. Quick principle of American law. You violate American law almost always, almost exclusively, when conduct is done intentionally, amazing. It is a leavening aspect of American law that if something happens or someone does something to show it, even if one transgresses physically the law, then that is not a crime. There is an example that I use sometimes in speaking with clients, and the example is sort of a simple one. Someone here is perhaps going to Muncie after this symposium. I say to such a person, here I have a package. Would you be so kind as to deliver it to your neighbor in Muncie? And the person says, fine. Now let's assume that this package contains contraband or some wrong product or stolen goods. That person would not have committed a crime. even though that person would have carried this package from here to Muncie. I, on the other hand, would have committed the crime. Now, what is knowledge? What is knowledge? At some level, knowledge consists not only of actual knowledge, but knowledge consists as well of conscious avoidance of knowledge. Meaning, if the facts are there in front of your eyes, and you consciously don't inquire further, you don't want to know. The law says that that is knowledge. That is guilty knowledge. So now we'll go back to this example of the package that I'm talking about. Now I ask this person who is doing me a favor and taking this package to Muncie, this hypothetical package, and I say to that person suspicious things. I offer that person a lot of money to take this package to Muncie. I suggest that this person hide this package somewhere in his car. If that can be shown, the law says you knew. The law says you knew. And even if you didn't know, and if you didn't know if it was stolen or it was any kind of contraband or drugs, I don't know, whatever, the law says you knew. So now let's come back to financial transactions. Changing a check for cash. It's kind of topical nowadays. That could be money laundering. That obviously could be money laundering. Don't get paranoid though. If somebody asks you to change a check for cash, why not? Seriously. If your neighbor needs a favor and he asks you to cash a check for him, why not? Cash the check for him. Don't be paranoid. On the other hand, don't shut your eyes either. Don't shut your eyes either. You take a look at the nature of the transaction. You take a look. Is there any kind of a likelihood that this check, this cash, is criminally derived? And if so, don't shut your eyes. Don't do it. So I will tell you, I've been reading about recent accounts of events of this past week. And this informer who set up people in connection with these transactions was very careful, according to the papers that I've read, the law papers that I've read, to basically implant all of the elements of money laundering. So if any of you have read any press accounts, what he did to these people is he said, I have money here. I have money here. This money is from a bankruptcy fraud. Or this money is from counterfeit trademark, Gucci, I don't know, whatever else it is. And so now, whoever is dealing with them, and when these things happen, they happen by design. Meaning when an informer comes out and speaks to somebody, there's a script. So they want to make sure that the other person that they're dealing with knows that this money is criminally derived, or has a criminal origin, or is trying to hide who owns it or who doesn't own it. And then they go forward with the transaction. Before you help someone, and you've heard this here earlier today, be really careful. Just be careful. Helping someone, doing a chesed for someone is not a defense under American